Hi, welcome back to another episode of Ante. I'm Alex Dolphin, and today we're going to discuss the case of Katko versus Briney. Katko versus Briney was argued in the Iowa Supreme Court in the year of 1971, and it deals with property rights and the rights of a property owner to protect their property from real intruders. So let's go ahead and discuss through the facts of the case quickly, and then we'll run through the issue and the ruling. So Edward Briney and his wife Bertha Briney, they owned a countryside home in Iowa. They had inherited the home from their parents, and they weren't really living in it. They were just kind of keeping an interest in the real estate and letting it appreciate over time. So because it was an old home and it was in the countryside and they didn't have close supervision, it kept getting broken into over and over again over a span of over 10 years. It just kept getting broken into. Mr. Briney eventually got fed up with this, so they put no trespassing signs up, and unfortunately it still kept getting broken into. The home did. Once Mr. Briney reached his boiling point and he was completely frustrated with the situation, what he did was he set a spring gun by the front door. So this gun was set and loaded with a spring so that when anyone opened the front door, it would actually shoot at the intruder. So the spring gun, Mr. Briney was so angry about it that he originally set the shotgun to hit someone in the stomach, which would have been devastating, but his wife talked him off that ledge and told him that he needs to set the gun so it would hit someone in the leg. So that's what he ended up doing, and he walked away. Well, of course, the intrusions didn't stop happening, and at this point we enter the plaintiff, which is Marvin Katko. Marvin Katko was in search of some old jars, is what he claims, from the home. So he broke and entered the home, knowingly breaking the law, to try and get some of these jars and try and take them from the home. Well, when he opened the door, Mr. Briney's concoction did, in fact, shoot him in the leg and took off the bottom half of his leg. Well, Mr. Katko was a little bit frustrated with this, as you could imagine. He was hoping to just get some free jars, not hoping to have a decimated leg for the rest of his life. So he brought suit against Mr. Briney, and the lower court upheld his claim of negligence. So he brought a civil suit saying that Briney was negligent in the way that he defended his property. He used unreasonable force when he defended it. So some of the issues at play in this case would be, can one use force to protect real property? What level of force is someone allowed to use when they are trying to protect real property? And does it matter if someone's property is uninhabited when it's being protected? So does that play a role in how much force the law is going to allow a property owner to use to defend their property? So we'll run through the ruling, which was not in Mr. Briney's favor. It was actually in Mr. Katko's, as the lower courts had ruled also for him, that because Briney's gun was considered unreasonable force, they allowed Katko to recover his damages for his hurt leg. So, and they actually gave Katko punitive damages, and punitive damages in the court are meant to, forewarn future actors, saying that we're actually going to punish this individual for what has gone on here. So they awarded compensatory damages along with punitive damages. So they saw fit to take the extra action against Mr. Briney in this case. In the ruling, I think there's one spot that's worth citing. It's in the Prosser on torts, which says, and this is what the court cited in their decision, and this says, the law has always placed a higher value on human safety than upon rights of property. So that's kind of the principle that overarches and guides the court's ruling, that there's a higher value on human life than there is on property rights. So there was a dissent by Justice Larson, and he notes that the jury instructions, and that's what we're going to contemplate in an appeal, and that's what the Supreme Court of Iowa contemplated in this case, was the jury instructions. The matter of fact had already been found in the lower courts. And Justice Larson's dissent noted that the jury instructions should have included a consideration of Briney's intent in relationship to the gun. So Mr. Briney had said that though he had let this gun out, or had set this gun up to shoot whatever intruder was coming in, he wasn't intending to kill or severely harm them. What he wanted to do was just scare them. So that was Mr. Briney's testimony as far as what his intent was. So Let's talk about some of the ex ante implications and just a hypothetical scenario. So the court cited that because there was no warning of the gun, it made it especially more egregious. So I guess it's worth asking, what if Mr. Briney had put a sign on the front door that says, "Warning, if you enter, you will be shot"? Then could Katko have recovered for a use of unreasonable force? Something that would be up to the court to decide, but definitely a variable that would change this course or this case and would differentiate it from a different suit. So truly the ex ante implication that I want to sit with for a little bit, and I think that Justice Larson noted, was that Justice Larson might not have explicitly noted it, but I do think it's what was underlying his decision and the incentives that the ruling of the court created in this case when they ruled in favor of Katko. So what this does is it sends a message to all people who are interested in breaking, entering, and stealing property from someone that they can do so without threat of unreasonable force. So that's kind of a scary consequence. If you own a home and someone wants to break and enter into your home and they just want to take your TV, but they don't have a gun, they don't have a knife. And this does depend, different states have different rules for these, but it's just worth noting that in the state of Iowa after this, that would not have been enough for you to use unreasonable force. And so that it kind of does incentivize people to feel comfortable stealing, breaking, and entering into people's property to take what they'd like from them. If they know they're not going to get killed or severely hurt, what's the real scare, right? There's a lot of desperate people with desperate measures that will steal anything to make money. And if they know that they can't actually be hurt or killed without, an opportunity for them to recover damages for that, and potentially even punitive damages, why would they be more and more afraid of stealing? That is one consequence that you have to think about of this. I mean, there's also the other side that if someone breaks into a home to steal a loaf of bread, do we really want to kill that person? I don't know. It's likely not, but it's something that we should think about. Another differentiator that I think is worth thinking about in this case is where do we draw the line between reasonable and unreasonable force? Unreasonable certainly might be a shotgun, but what about a hard fist to the chin, right? What if someone slugs someone while they enter their property? Is that unreasonable? I mean, if it breaks their jaw, maybe it is unreasonable. But that line is kind of muddy, and it's definitely gray, something that a lawyer could argue about in the future. Finally, the last thing that I wanted to consider is, will people, after this case and the message that was sent by the court, will people actually feel comfortable in defending their real property? And this does tie back to the case's precedent incentivizing more stealing, because those folks have no fear of real physical harm to them because of it. So does this case and this ruling and precedent that was set by the Iowa Supreme Court incentivize property owners not to defend their property? And I think it does. It would have to, at a certain level, make you leery or nervous of setting some type of trap or any type of defense against your property, because you might get sued for that. You might have punitive damages ruled against you, and you have to pay exorbitant sums of money. And could bad things actually be prevented with a reasonable, unreasonable use of force? Could we actually prevent stealing as a whole? I know it's kind of like a Singapore model where if you spit your chewing gum on the ground, you're going to be fined ultimately. But if all thieves knew that property owners could defend their property at any time with threat of deadly force or severe harm, I think people would be less likely to steal. There's a couple implications of the ruling and precedent that was set there. Thanks so much for watching.